8692S, you said? Yes, sir. Okay. All right, everybody. Hopefully we'll have another committee member come in, but we're going to go ahead and get started. Chairman Watson, I'm going to call Chairman, this is the Reeves Judiciary Non-Civil Subcommittee. And we've got 3 bills up today. I'm calling Senator Watson. It's on LC 338692S, Senate Bill 235. Chairman Watson, why don't you tell us about your bill? And do we have a sign-up sheet? Has that gone out yet? Okay. And we're not on Zoom today, so we can only hear from folks that are in the room, but if anybody wants to be heard, I'll call on you. So, okay, Chairman Watson, have at it.
Thank you, Chairman Reeves. Appreciate y'all hearing this bill. This mask bill has a decades-long history in state law, but because of the pandemic, Governor Kemp had to issue an emergency order to allow masks to be worn in the state of Georgia during the pandemic. So the law dates back to in response to the Ku Klux Klan about wearing masks in public areas or on private property without express written permission. And it goes to intent of the law, and so that is the original part of the law. What we're adding in is down there on lines 36, 37, and 38 to allow people. So let me just digress a little bit. When the governor's emergency orders expire, we'll obviously go back to the previous law. So that's why we need to add in to be able to allow people to wear masks in the future for protection. 36 through 38, wearing a mask for the purpose of complying with the guidance of any healthcare agency, i.e. like the CDC or Department of Public Health, or healthcare provider, i.e. your physician who may have just given you chemotherapy, wants you to wear a mask so you don't catch any other bugs out there. And then to prevent the spread of COVID-19 or other coronaviruses or influenza or other infectious diseases. That's all it does. It came through HHS, which does have 3 lawyers on there, and it passed the Senate 49-0. I understand that the prosecuting attorneys who actually represented the state of Georgia, I think, in the most recent case, the mask law, are here. And as we talked offline earlier, I'm certainly not interested in messing up the mask law from before. I'm interested in carrying forward when the emergency orders go away. So whatever makes it a better bill, I'm happy to have it done.
And so my understanding is that lines 19 through 23 might be what's being discussed, that is, I believe, language that might already be it's language that's presented to us through jurisprudence, through case law. Is that right?
That's correct. The Senate research person, Beth Vaughn, actually had written an article on this and brought what was in case law and put it into actual law. And so, again, I'm not here to mess up anything, and I'll defer to the experts, the legal authorities on this, as you guys are here, and it's much appreciated.
Great. Does anybody have any questions for Chairman Watson? Representative McLaurin.
Thanks, Mr. Chairman. Thanks, Senator. Just so I'm clear, is it lines basically 19 through 23 that are codifying case law as it currently is?
Yes.
Okay. That was my only question. Thank you.
You can see it goes to intent and wanting to be threatening and intimidating. And there are obviously exceptions, like for theater productions, Mardi Gras, sporting activities, and gas mask and Halloween, that kind of thing. So, which would be sort of obvious.
Do you feel comfortable that number 5, lines 36 through 38, that this, I think, or other infectious diseases is the key that would allow this to qualify for other similar things, but you feel that language covers what we need to do once the executive orders are done, and the mask rule is no longer once the executive order goes away, this will get this done.
Right, so there could be other illnesses that are in the future that may require more emergency orders, but this would probably make it so that you wouldn't have to do that. In other words, like in coronavirus, you're moving from animals to humans, and this was certainly an exceptional thing, and hopefully it's another 100 years before we have another thing, but it may not be. So I think that would take care of that.
Does anybody else have any questions for Chairman Watson? Okay, if you each want to have a seat, is somebody from PAC can somebody from PAC talk? I'd love to hear kind of some thoughts about the case law and the positive or negative things that could be associated with codifying it. So
I think the PAC guys actually stepped out. My name is Sandy Weisenbaker. I'm the Solicitor General in Coweta County.
yeah,
We actually had a case, Ms. Grenade, Elena Grenade is with me, she's an assistant solicitor, that she tried. She heavily researched the case law as it relates to the code section, which is now currently still up on appeal. It's in the Court of Appeals as we speak. And she'd probably be in the best posture to answer any questions that you might have in that regard.
tell us your name one more time. Elena, what?
Sure.
Hi, it's Elena Grenade, just like a hand.
Wow.
Yeah.
I've never met anybody with the last name Grenade.
It's a very fortuitous thing that I'm a prosecutor, I suppose.
Right.
But yes, so I am an assistant solicitor in Coweta County. I work for Ms. Weisenbaker. Have done so for a few years now. Before that, I worked in the Griffin Circuit as an assistant DA. So I've kind of devoted my career to prosecution. And one of the cases that I did have the privilege of trying as a solicitor was this mass case. Now, I don't know how familiar you all are with the history in Coweta County, but in 2018, April 2018, there was a rally that was held by a group called the NSM, the National Socialist Movement, I believe. It's kind of like a KKK group. They wanted to have a rally. They went through the proper avenues and petitioned and got their permit to have a rally. It was just a few of them, but in response to it, a number of, we called them anti-protesters, kind of descended upon Noonan, the downtown area. To the number, thousands of them came. So kind of in response to that, the local law enforcement familiarized themselves with some of the laws that they would be looking to enforce that day. They were aware of what had previously happened the year before in Charlottesville, Virginia, where a very violent protest happened. So they were very well prepared this particular day. They were very well prepared on the law. The mask law was one of the ones they knew they would be enforcing, as well as other misdemeanor crimes like obstruction. The day of the rally, the protesters came, they did their thing, and many of the counter protesters came, and it was kind of very positive in the law enforcement reaction to it. The law enforcement officers made a very limited number of arrests, and they did only arrest a few for the anti-mask statute. So when we had this trial, it was a 3-day trial, which if you've ever sat through a misdemeanor trial, it's very unusual to have that lengthy trial for this purpose. But we had a number of witnesses, a lot of testimony, and essentially what ended up happening was the local community convicted the individual for both offenses, obstruction and wearing a mask. He was wearing a bandana as well as other facial coverings.
And so was this an anti-protester, or is this a person that was a member of the NSM group?
So he was an anti-protester. In fact, the only people arrested that day were the anti-protesters. None of the NSM individuals were arrested on that particular day for this particular event. So he was one of the anti-protesters. There were several of them. This was one of the few that went to trial. Kind of interestingly enough, when we sat down to prepare for this trial, we reached out to the local community, because this is not something that I had ever tried before, nor had Ms. Weisenbaker in her number of years of experience. We reached out to the local prosecution community to find out, hey, does anybody have any information on how to go about trying this? And crickets. This is a law that is very rarely prosecuted, very rarely taken to trial. Sometimes you'll see it as a tag-along for a felony case if an individual goes into a bank to rob a bank or something. But it's very rarely a standalone charge. And so the ironic thing is that the law itself was enacted because of the KKK and because of those types of violent groups, and in response to the violence that the effect when they go up in these traditional Klan costumes and other facial coverings with the intent to harass and intimidate. So that's kind of the part of it, and we kind of struggled for a little while on how to go forward, but we ultimately did. So the intent to harass and intimidate is the proper intent, and it's in the case law. It's not in the statute. But you do, when your statute doesn't have your intent, you defer
Your jury
to
charge, and so you were able to get a jury charge out of the case law, is
yes,
that right?
Yes. So we actually had our accusation. We included it in the accusation, the correct intent. That was from the Daniels case from 1994, and it's specifically, a two-prong test. You have to wear a facial covering and have an intent to conceal your identity. And then in addition to that, you have to have an intent to either threaten or intimidate somebody else or act with kind of criminal negligence. And the language of criminal negligence is outlined in the case itself. So we included that in our accusation. There was a jury charge on it as well, and it went forward to the jury, and they ultimately convicted.
Were any of the NSM participants wearing masks or no?
To my recollection, I do not believe they were wearing any of the traditional Klan regalia. I was not present for the rally, so I don't know.
Sure. So let me, I'm unclear. What is your position on codifying this language? I mean, obviously you have experience with this statute. What is your thoughts on codifying that language as it's presented to us right now? And are you able to look at a copy of the bill right now?
Yes, I am. I think it creates a problem where you don't need to have a problem. The appeal actually went to the Supreme Court first, and the Supreme Court addressed it, and they came out very quickly with an order that essentially said, this has already been decided. So essentially the appeal was that the statute is unconstitutional because it does not include the language of the intent on the face of the statute. That was their basic argument on appeal, and they sent it to the Supreme Court. The Supreme Court very quickly said, no, we've already decided that this statute is constitutional 2 times now, and because of that, we don't have jurisdiction over your case.
So by codifying it, does this essentially create additional elements that would have to be proven, whereas before it would be a little bit more vague? What's the harm in codifying, I think is what I'm trying to figure out.
It creates this illusion that the law has changed when in fact it hasn't changed. And that creates a barrier for prosecutors and for going forward on this law under the circumstances that it would be in the future once we're out of the preventative orders. It creates this illusion that this law has changed, that we now have to find some other way to prove this case when in fact it's already out there. It already exists. You have to have in the language of the accusation or the charging document, you have to have the intent language. It has to be there, or you would be subjected to a demurrer. Your charging document would get thrown out. If you have it in there, you still have to prove it at trial. You still have to convince a group of 6 or 12, if you're in superior court, jurors that you have proven the requisite intent by virtue of all the surrounding circumstances.
So, and I don't necessarily have an opinion one way or the other on it, but one of the things that comes to mind, obviously the official code of Georgia, while in a lot of cases is very complex even for lawyers to read and figure out, what it is that we meant up here when we do certain things. But for a layperson or citizen, non-legislator, non-lawyer, the idea is for them to be able to access the official code of Georgia and read and derive from that what they can and can't do. And it is unlikely that there's a big disconnect, I think, between the reality of going from reading the code to inform yourself, but then, and this isn't unique to this situation, but then requiring essentially that somebody would have to have access to case law and be able to read the case law to really further understand what they are and aren't allowed to do, or what the elements are and the things that actually would make it a crime. And so, and again, I don't have an opinion one way or the other at this point. I just sometimes, clarifying this, I think can assist with the public's understanding of it gives greater context to this, and it also better explains, well, these are the kind of things that are illegal, et cetera. Do you have any thoughts on that? I'm not trying to put you on the spot.
Sure. No, and I think the addition of the language that is relating to wearing the mask for the purpose of complying with a healthcare provider's orders or to prevent the spread of disease is curing that problem. Nobody who's out there wearing, like I am today, a Mickey Mouse mask to come talk to you guys is out there trying to conceal their identity for purposes of committing crimes. And so I think the people who are going to be violating this statute, and even the general public in and of itself, I think they're going to understand that they're, by virtue of adding that in there and by virtue of the knowledge of having lived through a pandemic for over a year, they're going to understand that they are able and allowed by the law to wear the mask for the purpose of preventing the spread of disease or to comply with healthcare restrictions and orders.
What is there anything in this language that is inconsistent or adds anything to the elements that are derived through the case law? Is there anything
Sure.
that you see here that doesn't that's unique from the case law?
In regards to the way that it's written in the proposed bill, it's not the exact verbiage from the case law. It's flipped a little bit, and it creates a bit of confusion as well. If you read from the Daniels case, and I can read it out loud for you, it's a two-pronged test for the standard. That in order to obtain a conviction under the Anti-Mask Act, the state must show that the mask wearer, number one, intended to conceal his identity, and two, either intended to threaten, intimidate, or provoke the apprehension of violence, or acted with reckless disregard for the consequences of his conduct, or heedless indifference to the rights and safety of others with reasonable foresight that injury would result. So I think the way that it's written is either you act with that specific intent or you act with the criminal negligence. But the way the bill has it proposed, that by including with reasonable foresight that injury would probably result first, is not the correct standard. It needs to be part of the verbiage for the criminal negligence. And so that would be, my issue with specifically the way it's written. But again, I would think that it needs to be taken out just in total.
It's interesting. Obviously the negligence standard is extremely rare, and I think, I know it's in reckless driving and some of those, but I think there might be some cruelty to children charges, but it is very rare in criminal code that we have the reckless, the negligent language kind of cross over into that criminal code. But that, Chairman Burchett, did you have a question?
Thank you, Chairman. No, I was just going to kind of expel further on what you were kind of getting at. If these cases aren't being had very often, and we don't codify this language, it seems to make it simpler for a prosecutor to know that it's there without having to dig into the case law. I wanted to see what your thoughts were on that.
Well, it is the duty of any attorney to know not only what the statute says, but also what the case law is. So it is our burden to know that in general. And so I don't think making it harder, I don't think it is making it harder, because we have to do that anyways. Any attorney who's worth their weight needs to be able to not only just look at a statute, but also investigate it and make sure that everything is, or have the resources. For one, we have the prosecuting attorneys council. They're a huge benefit to us, and so we can reach out to them for anything. And in fact, I did multiple times on this case because of kind of the nuances in it. And Mr. Smith was a great help in helping me kind of wrap my head around it. So I don't think that it's difficult, and it was brought up by the defense bar, so they knew about, the necessary intent. I think it was very well known that the intent needed to be in there and also proven.
McLaurin, did you?
I guess, thanks. One question I had was the scope of the word injury on 20. Does that in any way address what you're talking about? If injury could refer to even potentially an emotional, as long as it's a cognizable injury.
Well, I think it's a strange phrasing too, with reasonable foresight that injury would probably result. So you're asking a prosecutor to be able to foresee what a defendant's actions could do to another person. And if you, in fact, step back and read the Daniels case, the one from 1994, that did not deal with the KKK. That dealt with an individual who put on green facial covering, such as we wear nowadays, and a helmet. He was a slower individual, and he wanted to entertain some children, and that was his specific intent, what he intended to do. An officer who was off duty noticed him trying to entertain the children and took it upon himself to come over because he thought one of the girls looked like she was uncomfortable. Ultimately arrested him, and the Supreme Court said, whoa, your thought on what somebody might be feeling is not sufficient to meet this standard. So I think it's just dangerous to have that language in there because it's incredibly hard to try to figure out what injury might occur and what the defendant's thought of that injury is, if that answers your question.
And makes it susceptible to challenge.
Yes.
Okay.
Is that language is that language that is not in the cases that we derive the elaborations of the statute?
It is, but it's it's phrased differently. So that's part of the criminal negligence standard. So it really should be kind of after B and C. So it should be, intends to conceal his identity and intends to threaten and intimidate, or acts with reckless, and then, read B, read C, with reasonable foresight, that injury would probably result.
Does anybody else have any questions for Ms. Grenade? Thank you. Your testimony was very helpful, and just stand by in case we need you to answer anything else. Does anybody else in the room
Thank you for your time.
want to speak on this? Okay, so what we're going to do is Representative Lopez.
Thank you, Mr. Chairman. I had a question for the author, or I can just share my thoughts on Section B. I see that there are some exceptions for someone wearing a Halloween costume or holiday costume, and other exceptions. My concern is not having a exception for a religious practice. I represent Clarkston and a big immigrant and refugee community, and that will be very important for me to include in this bill.
I'm reading the language to see if Chairman Watson, is that obviously the law as it is right now, most of this is current law, and what Representative Lopez just said, at least from a quick reading, doesn't seem to be covered. Is there any part of this that you believe would cover the concept? Because there's...
No, I do not believe that would be covered. That was not my intent of the legislation.
Sure.
The intent of the legislation was lines 36, 37, 38. There has been other legislation that has been introduced in the past few years or so that did address religious aspects of that, but that's not something that was my intent, and that was not something that I think that's been addressed with emergency orders. So again, we had the mask law. It's illegal to wear a mask, and then emergency orders allowed it to be legal because of this pandemic that we're in. And then so when the emergency order is over, we go back to the previous law, from a mask perspective. That's why I did this. That would be something, another piece of legislation or the will of the committee.
Sure. And so I think what we're going to do is there anybody that has any questions for the author of the bill on that issue or anything else? So what we're going to do is I'm going to look at the issues of lines 19 through 23 and have some discussions about the pros and cons of going ahead and codifying that versus striking it. It sounds like it probably wouldn't be necessary. I think either or would probably be okay. There might be some ways to reword line 20 if it was left in. And I think that while we're at it, if there is some reason why religious I've just gone about as blank as you can go. Religious activities, practices would be intentionally excluded from that. I can't think of any right now, but I would be interested to see if there's any history behind that one way or the other, and maybe that's something that we could amend to address the representative's concern, but Representative McLaurin.
Thanks, Mr. Chair. I mean, I guess my way of thinking about it would be if the intent of B is to cover all the legitimate uses of a mask that we can think of, then I would support that amendment for that reason, because, I understand that it's not currently covered as an express exception, but if the purpose of B is to basically enumerate legitimate purposes, and the current phrasing we have for the purpose of as, a way of identifying that it's legitimate, then I would obviously support Representative Lopez's amendment.
And I think what's interesting is that line 24B says, well, I guess this would be a new, without limiting the generality of subsection A, and does that create wiggle room? I don't know. We'll look at it and we'll figure out. I understand your intent, and doesn't sound like you have a dog in the fight on the other kind of collateral things that are being discussed. So. No. We will take a stab at it, and I will get back with you, and then we will bring this thing back up. So thank you, Chairman Watson.
Thank you, Chairman Reeves. Thank you, committee. Appreciate it.
Is the pro tem still in here? He's on the hall. I'd love to. I'm just not going to call Chairman Strickland before I call the pro tem. I'm just not going to do it.
I'll do the same thing for you when he comes back.
I have a feeling you will. So. Mr. Pro Tem, we're honored to have you in our committee today. Thank you for being here, and I know that you're a busy man with a lot of responsibilities, and so I appreciate you being here. Tell us about your bill. I'm on Senate Bill 117, LC 413017S.
That's correct, Mr. Chairman, and thank you for letting me be here, and thank the committee members for letting me present. And this is, as you mentioned, Senate Bill 117, LC 413017S. I'll speak briefly about a situation that occurred in Hall County and why I am here with this bill today. So we had a community coach that worked for one school system that had an inappropriate relationship with a child from within our school system, but at a different school. And because of that different school relationship, that coach was not able to be prosecuted as a felony. It was prosecuted as a misdemeanor. And we know of these situations that have happened, a record in Clark County, Chatham County, and Hall County, all within the last couple of years. So I think this is a loophole that needs to be closed. And this bill revises the code section for the crime of improper sexual contact by an employee or an agent in the first degree as it relates to a person who is a student. And additionally, it provides for the offenses of improper sexual contact by a person in a position of trust in the first and the second degree. And I think that position of trust is key here that we want to make sure we bring out. And these are people that have been entrusted to care for our children, and whether it's a coach, a tutor, or what have you, someone that we have entrusted the well-being of our children. I've got happen to have with me here Mr. C.R. Chisholm from Clark County and Mr. Pete Scandalakis, who both of them may be willing to speak to the bill.
Great. Does anybody have any questions for Pro Tem Miller? Representative McLaurin.
Thanks, Mr. Chair. Good to see you, Mr. Pro Tem.
Thank you.
I'm curious because, I don't have an encyclopedic knowledge of this area of the law. I know we worked a lot on this statute in previous years. Do you know what the current punishment would be for somebody in this position and how it differs from the bill?
The two gentlemen I mentioned earlier could probably answer those questions more direct.
Okay.
I can read it off my paper. They could probably speak to it in greater. Yeah.
Sure.
No problem. Thank you.
I've got the Cliff Notes if I need them.
Yeah, sure.
And-
Absolutely.
And it's this committee is we this is your bill, right? From we have this committee is very familiar with this concept. We took this up for frankly several years to get the structure that's in place now, and so we've spent a lot of hours on this issue with this. Does anybody in the committee have anything that they want to ask the sponsor? Can we get Mr. Chisholm and Mr. Scandalakis up here?
Thank you, Chairman Reeves. I appreciate the opportunity to speak to you. If it's okay, I would like to explain a little bit why I'm here, why I'm interested in this bill, and it pertains to a case that I prosecuted in Athens, Clarke County a couple of years ago. When we get cases in the Solicitor General's office, they're misdemeanors. That's all we get. We don't get felonies. We do get sexual batteries, and there are misdemeanor sexual batteries. When we get sexual batteries in our office, pretty much so all of those cases are from a spontaneous occurrence. You'll have case facts where somebody's downtown, they touch another person's genitals, breasts, buttocks. They do so inappropriately without permission, and it's intentional, and they are usually, there's some type of alcohol involved. We get the other cases where individuals may know each other, maybe been drinking, and they might be friends, but overall, maybe one tries to take it to a little bit further than friendship. The other one sometimes is mental health, and we get sexual batteries in cases that mental health is the issue involved. But usually it's always strangers. Usually it's always just one touch. But that changed for us in 2017. My victim advocate received a phone call, came to my office and said a mother just called, said that her daughter had been the victim of a sexual battery, inappropriate touching by her soccer coach who was training her, and he touched her while stretching. And, I immediately went to what our normal cases look like, and I thought it was a one-time touch, and I'm embarrassed to say that I jumped to some conclusions and thought this is probably a big misunderstanding. But as a prosecutor, I shouldn't do that. I need to look at all the case facts and everything before I make that judgment, but that's my initial reaction. So I asked for the mother and her daughter, who was the victim in the case, to come in and meet with me a few days later to find out what happened. The mother that I'm speaking of is Tracy Chu. She is here with me today, and she would be available for you to ask any questions or speak if you so choose later. Cameron, her daughter, could not be here. She is a student at UGA, and she had to be in class. When they came and met with me, they told me that the person that did this was somebody that they had known in the soccer circles in Athens for a number of years, that this defendant had coached her older brother, had coached her on a team, and that he had opened a soccer training facility and had been training Cameron for years, all through high school. Up to this point, there had been no issues. They had a great relationship with him. He had become a friend to Cameron and of the family, and so much so that she was babysitting his children and got to know his wife. So she was almost like part of the family there. When she rolled around to 17 and she was a senior in high school, she was still playing soccer, had a bad game, wanted to improve some issues that were in her game, so she contacted the defendant, asked him, "Can I come in and work on my shooting?" And he said, "Sure, come on by." And they trained that afternoon. Nobody else in the facility other than the two of them. At the end of the session, he said, "Look, that was a hard session. You're shooting a lot. That's going to work your legs. Let's stretch those legs out so that you'll be okay for your next game." So this was the first time that stretching had occurred. All through high school, no stretching. All of a sudden, we're stretching now. He had her lay on the floor. She's wearing a T-shirt and soccer shorts. Had her one leg out, prone on the floor, and he got down on his knees, straddled the prone leg. He took his left hand and put it on the other leg, the knee, and pushed the knee towards her chest. It was the other hand, though, that was the problem. The other hand is on her thigh, and it's high up on her thigh. His thumb went up underneath the leg of her shorts. She thought it was a little unusual, thought it was a little high, but outside of that, he's talking to her, communicating, everything seemed normal. After that, he told her to come on back and train again, and she did. When she came back the second time, same stretch, this time at the beginning of the session. This time, the hand also went up the thigh, thumb under the shorts, then the thumb slid up underneath her underwear and was on her vagina, unclothed. She thought it was very strange at this point. I asked her, "Why didn't you say something?" And she's 17 years old. She's a high school kid. She thought, that he was just doing it by accident or just didn't realize he was touching her there. And she thought it would be embarrassing or awkward to say something, and so she just accepted it. Not long after that, she broke her leg. She couldn't train for a few months, came back because she wanted to get back into soccer. Well, the stretching continued. And again, I'm like, well, why aren't you saying something? And she said, everything seemed normal other than that. He's talking to me the entire time. It's just conversation that's going on. And it's about me. It's about my team. It's about school. It's whatever. It's about his kids. All of those things, making it seem very normal. Then at one session, at the very end, he not only put his thumb under her underwear, he put his entire hand under her underwear and is cupping her vagina. At this point, she realized, all right, none of this was an accident. None of this was incidental. This was all very intentional. She slaps his arm. She gets up. She leaves, and she reports it, and warrants were taken. So not long after that, as I'm talking to the Chews about this, and they're telling me about all of this, they inform me, yes, actually after they had come out with this, that another girl, also 17 years old, reported to her father that this defendant had been training her, stretching her, and touching her in the exact same way. So we have two of these cases at this point, and I know with sexual battery, the second one can be a felony. So I'm thinking, look, this is predatory behavior. This is very intentional. It's very calculated. And this is way different than any sexual battery that we've ever had before. This has to be a felony. This can't be a misdemeanor. So I got into 1665.1, and I'm going through 1665.1, and there is nothing there to help me.
Because the categories are...
It was school.
Yeah.
Yeah,
child welfare, youth services, foster parent, school.
What year was this?
2017.
Psychotherapy is another one.
Yeah,
So.
Mr. Chairman.
Mhm.
Mr. Chairman.
Yeah, you're good.
Your solicitor is spot on. We tweaked this bill in 2019 to address agents of schools. We had a circumstance at Kennesaw Mountain High School, my own district, with a circumstance because if they weren't a teacher or a principal, it didn't apply. In 2019, under Senate Bill 9, we expanded it to any agent of the school. So if there's an agency, like a community coach that didn't have to be paid, if there's an agency responsibility, what you just described was the purpose of the SB 9.
He wasn't an agent of a school. He coached travel soccer, a private soccer league or team. He coached that. Had no school affiliation, and his business had no school affiliation. The only thing that may have had a loose school affiliation, he might rent his facility out to a team to come in and use it because you could play indoor soccer there. But he didn't volunteer at schools. He might come and watch a game at a school, but that would not put him under that definition. But to answer the question earlier, the current law for this, if it's first degree, I think it's 10 years or 25 years, $10,000 fine is the maximum penalty. But going back to this, we had no recourse. If he had been a coach at a school or even a volunteer coach, we could have gotten this up under a felony. But we didn't have that either, even though the dynamic is the same. I mean, if you're a parent, you're still trusting your child with him in this private setting as you would be as if this happened on a school campus. So what we decided to do was we said we're going to go forward with the misdemeanor charge on this first one with Cameron as the victim. And if we get the guilty verdict, then we're going to send it on, the second one on to the DA's office and get the felony. The goal for us was trying to get sex offender registry. So we did. We went forward with the first case. We got the guilty conviction. I'm not going to go into the excruciating details that happened thereafter, but we had a juror issue that compromised the transfer of our second case. So we ended up keeping the second case. He ended up pleading to the second case. He ended up with 2 misdemeanors. He has now finished the sentence. There is no sex offender registry, and that's where the real problem starts coming in. He can now go out and reopen a business, and he can start retraining kids just like he was doing before.
Is he doing that?
To my knowledge, he isn't,
Okay,
and I hope he doesn't.
sure.
And that's not the outcome that
Yeah.
the Chews wanted, or the Allen family wanted, that was in the other family. That was not what we worked for well over a year in working on this case. We really wanted that sex offender registry and have that there, because the facts of the case deserved it. And it didn't happen. But we shouldn't have gotten the case to begin with. We shouldn't have had to try a case to get it to the next step of being a felony. That shouldn't have happened.
Let me ask you this: the fact pattern that you described makes perfect sense in having a mechanism to hold that person accountable in the same spirit of the rest of this law. Makes a lot of sense. And I think that the one thing that I would want to look at is when we define person in a position of trust, have we reached the best definition of it? Are there is it too broad? Is it perfect? Are there scenarios that we can envision that would meet that definition, but that would be outside of what the spirit of what this law is, or what this policy is attempting to do? And so I say that I'm not speaking ill in any form or fashion of this, but having had this issue before this committee for years, we've definitely spent a lot of time on this and crafting it. And so the question that I think that I want us to look at is, does person in a position of trust, is that the policy? Is that broader than the policy that we want to move forward, or is that the right language? And I mean, what are your thoughts on, so it has to be a minor, right? Yeah, a custody of a minor. So the person in a position of trust would have to have that position with consent of the parent, guardian, or other person having charge or custody of a minor, and then that duty and responsibility is limited to health, education, and supervision. I'm thinking about this for the first time, at least in this context, and this is what, and the I need the committee's help with this. Does this potentially capture situations that are outside the spirit of this law? What are your thoughts on that, Mr. Chisholm?
Yeah, certainly. But this is something that when trying to develop this language, we did research on this ourselves, and there are currently, and I say currently, we looked at this about a year ago in preparation for last year's legislative session. But there are 11 states out there right now that I'm aware of that have private actor sexual contact statutes. And there are 5 of them that use position of trust language. Tennessee, Arkansas, Kentucky, Mississippi, and Colorado.
So again, Tennessee, Arkansas, Kentucky,
Mississippi, and Colorado. And that they also, it's a felony in Tennessee. It's under 18 in Tennessee. And they've already had a case in Tennessee. This is the one I thought was the best. State versus Kissinger, 922 Southwest 2D 482, and it was. Looks like it was from 1996. So they've had it for a while. And it says the determination of the existence of a position of trust does not depend on the length or formality of the relationship, but on the nature of the relationship. So it is factually driven. And I'm not sure if you start trying to narrow this down, you're going to ultimately end up putting labels and buckets of different categories, and you're going to miss one of them. It's the nature of the relationship that really drives this. And, we limited the definition in the current 1665.1, and it didn't capture what happened here. So I think that's the concern, is that we're looking more at the nature of the relationship, and it's going to be hard to boil it down with categories in an effort to narrow that.
I can see that, yeah. Anybody have any thoughts or questions for Mr. Chisholm?
Mr.
Yes, you're live, so.
And I'm not speaking on either side. I'm just trying to, for Mr. Chisholm and for members of the committee, to understand, just for purposes of clarity, and again, I'm not being antagonistic. I just want, for purposes of the committee, to understand what you're trying to do so we can get our mind around it. So the 1665.1 addresses really a number of things. One thing that's, I think, interesting from a legal perspective is that it has a context in which underage 18 people are contemplated. Of course, the age of consent being otherwise 16 in the state. There's minors that are in this, and there's also a number of these code sections which deal with people over the age of 18, where even consensual sexual contact is still a crime because of the nature of the venue. You know, for example, if there's a 35-year-old person in a healthcare setting who's the patient and a 35-year-old person who's a healthcare provider, any sexual contact, even if there's otherwise consent, is still a crime under 1665.1, because even though they'd be otherwise consenting adults, this makes it a crime because of the nature of that healthcare setting, or being in a prison or in confinement or probation and so forth. So that exists throughout this code section. One thing here that this raises, it may be your intention, I wanted to ask, just for clarification purposes, is this seems to suggest on 45 through 48 that if you have an employer, a 22-year-old, 23-year-old manager of a fast food restaurant, if there's sexual contact with a 17-year-old, obviously 16 typically being the age of consent, I just want to make sure that it's your goal in this, as we talk through this, that, I mean, it would be the policy objective that a 21 or 22-year-old shift supervisor with a 17-year-old employee in a fast food setting, sexual contact would be a crime.
It would be. It would still be. But that is the intent, is to keep it the way we have the language right there.
I was just trying to make sure, okay, so we're clear about that. Also, I will just say, too, on line 68, for purposes of discussion and context, included but not limited to a volunteer, that's, again, policy question for the committee. I mean, the language that was framed initially was one of agency. If you're an agent of the school system, which doesn't mean you're a W-2 employee, but you have an agency role, i.e. you're put in charge of something, you're put in charge of kids, as opposed to what we talked about euphemistically, the band dad that's rolling the xylophone onto the football field. They don't have an agency relationship over the kids, so that they would be outside of the law we had crafted before. This would open it up to a volunteer, potentially, whereas before volunteer was wrestled with, and we drew the line at agency. So I'm not speaking on behalf or against, I'm just trying to frame the question to make sure we're clear on the issue. So
I think you are. Yes, sir.
thanks, sir.
Anybody else have any questions or thoughts for Mr. Chisholm on this? Okay, thank you, Mr. Chisholm. Just stay by in case we need you.
Yes, sir, thank you.
Is there anybody else here that wants to speak on behalf of the bill in any way? Miss Maisie Lynn Causey? And just introduce yourself and who
Certainly.
you're with.
My name is Maisie Lynn Causey.
You might want to take your mouth, it's just muffled a little bit.
Yeah,
it's up to you. You don't
I'd
have
rather
to.
not, if you can
Okay.
hear me well enough.
Perfect.
I'm Maisie Lynn Causey. I'm general counsel at the Georgia Association of Criminal Defense Lawyers. Appreciate just a few minutes. Chairman Reeves, you've raised one of our largest concerns, and that's the breadth of the definition of the person in a position of trust. We also have concerns about the way the penalties in this legislation marry, or in our view, do not marry well with child molestation. Now, I realize by raising this issue, we are also exposing that code section to potentially elevated penalties, if that's the policy desire of this body. But in this case, for instance, that was mentioned today, the 17-year-old alleged victim did not, and ultimately victim, and I don't mean to discount that, but the 17-year-old victim that was mentioned today did not qualify for a child molestation prosecution, because that is for, victims that are under the age of 16. So we would ask for some consideration around making sure the penalties between these code sections marry. That might look like carving out a penalty in this code section that you're considering in Senate Bill 117, so that if the alleged victim is 16 or 17, it then matches the child molestation scheme. As you probably realize, child molestation starts at 5 and goes to 25 versus starting here at 25 if you're under 16. So those are our major concerns: the breadth of the definition and the disparity between sentences for very similar behavior, arguably in some cases potentially more egregious behavior, not matching up and lining up from a policy perspective.
Does anybody have any questions for Ms. Causey? Okay, and what I would like to do, we're going to hold this. I think I understand Pro Tem Miller had to leave. Tyler, if you have anything else you want to add, you don't have to, but if you want to. But one of the things that I would like to see happen between this week and next week is looking at, especially at the definition of person in a position of trust, and really dive deep into that and figure out if there is a way. I understand that the perfect being the enemy of good, or good being the enemy, however it goes. That it being broad is intentional in some ways, but I just want to make sure that that we are looking at that as carefully as possible before moving on this. But Tyler, what did you have anything you wanted to?
I just wanted to thank the committee for their time, Mr. Chairman. Again, Pro Tem Miller regrets that he had to step away for another committee meeting, but I will certainly relay the thoughts of this committee, and we have spoken with Ms. Causey, and I'll continue to work with Mr. Chisholm as well. But we thank the committee for their time, and I'll relay that back to Senator Miller.
Great, and I think Chairman Setzler had a question for you, Tyler.
I was going to say to the committee, and I appreciate on line 46, we wrestle with this issue of agency or volunteer. What I see the bill doing is it's broadening the potential people that could be included in this. However, the limiting effect of your bill on line 46 is immediate charge or custody. So that has language that sort of draws in this idea of charge or custody responsibility in loco parentis, perhaps. So what we're weighing out here is just what are the boundaries of these fact patterns that could be in or out, and I think that's an important limiting factor in that.
Mm-hmm.
Sure, yes, sir, and I do recall this issue being one that we worked on in my former capacity with the AOC, but I will continue again to relay those thoughts to Senator Miller, and we'll look forward to continue to work with this committee on tightening that language should y'all desire to do that.
Okay, that sounds great. Okay, thank you. Chairman Strickland, it is a great honor for this committee to host a person who used to be a member of this committee back in his heydays, when he was really somebody, when he was in the House.
Sure.
But
it's been a while, but I see some things never change.
I see that we're getting a bunch of bills from Senate Judiciary right now coming over to this committee, and I think we're getting an idea where we can point our fingers.
Yeah, I think starting today we're going to be a lot more thorough on the Senate side with our hearings too. Now I've learned something already just in sitting here. Give me a start.
Absolutely. Okay. Tell us about your bill. We're on LC 412961S.
Good to see everyone as always. We're on, you already announced the LC number, Senate Bill 105. I'll walk through the bill briefly, and there's a lot of people here that want to speak on this. Back in 2017, for those of y'all that were around then, we had Senate Bill 174 that Senator Kennedy carried on behalf of Governor Deal. They created these behavioral incentive dates for probation termination. The policy was if you are on a probated sentence, your first offense, you're sentenced for less than a year in jail, you've served 3 years of your time. If you've done everything you're supposed to do, you followed your general conditions of probation, no other offenses, then into your sentence is a behavioral incentive date, your probation gets terminated. Despite us going that direction, there's a couple other areas you'll hear about in the law where probation can be terminated. Based on similar acts, based on good behavior. Despite that, we know that the data says that there's over 50,000 people in our state right now that qualify to have their probation terminated, yet less than 1,000 people have taken advantage of this. That ends up costing, estimated numbers we had from the budget office in the Senate, we're spending about $34 million a year supervising people that should be off probation. That's the numbers side, but bigger than that, think about the 40-something thousand people in our state that should no longer be on probation by our current law yet are still answering to a probation officer, still having to tell a landlord, have to tell a boss that they're on probation. And so with Senate Bill 105, what we're doing is we are streamlining the process, clarifying certain parts of the code to make sure that we are actually allowing people that have done everything they're supposed to do to still get off probation the way they should be doing it currently under law. So let me walk through the bill briefly. Mr. Chairman, I know y'all are a very thorough committee, not just saying that sarcastically because it's true. And so you probably already read the bill, but I'll briefly go through the sections of it. On the second page, you'll see the current law there dealing with behavioral incentive dates. What we're doing is cleaning up, first off, you'll see starting on lines 35 all the way through lines 42. We're setting a new standard you'll see in a couple other places in this bill for when someone qualifies to have their probation terminated. They paid all their restitution. They have not had a revocation in the last 24 months versus this standard of they generally comply with everything. They have not had probation revoked in the last 24 months. And they have not been arrested for any other non-serious traffic offense during that time. So you'll see we clarify the process that makes you eligible for early termination of probation on the behavioral incentive dates. On the next page, you'll see we then streamline the process itself. The way the process currently works is once someone is qualified, an order gets automatically sent to a judge. And if the prosecutor doesn't object within 30 days, that order gets entered. What we've done to make sure that's actually happening is two things in this section. One, you see that the court shall set a hearing within 90 days. If there is an objection, there has to be a hearing on this to make sure this doesn't sit with a court and have that delayed in that way. Bigger than that, even in line 55 through 58, you'll see that we're requiring that these behavioral incentive dates are actually put in these people's orders that qualify for this. If it's not put in, as we're seeing we've heard a lot of different reasons why we have those crazy numbers I mentioned of people that ought to be off probation or not. One of the big things we've seen is a lot of our courts are not putting these dates in sentences when they should. And so it says by law, if there's not one there, it's automatically by law. You still have that behavioral incentive date automatically put in there by law. Getting into the next section of the bill on page 5, this gets into another way that probation can be terminated, and this is the general right of someone to petition for early termination of probation. You'll see in this section, lines 107 through lines 110, we set that similar process where we have a hearing built in if somebody does object to make sure, again, that a judge does rule on those petitions to have probation terminated. Finally, getting to page 7 under section 2, there's also a process in a current law where every 3 years, if somebody is on probation, after every 3 years of that sentence, it's reviewed by the probation officer overseeing their case. And at that point, if the person meets the standard to have their probation terminated, they actually send a recommendation to the court to have someone's probation terminated. And you'll see here, we changed that standard as to what has to be met again on lines 169 to 170 versus this general and special conditions of probation being followed. We're saying that the probation was not revoked in the last 24 months. We're also clarifying, starting on lines 173 on the next page, that if early termination is recommended, then the department shall notify the prosecuting attorney and provide the court with an order causing that termination. And once again, you'll see that we put in here the prosecutor can object within 30 days. If they don't, it automatically gets granted, and the court will hold a hearing within 90 days if there is an objection, so the court can make that decision and it doesn't sit. Finally, you have the last section here starting on line 184. Again, current law, certain qualified offenses where someone is eligible to have early termination of probation. And this, again, clarifies that process. Instead of saying that someone did not have their probation revoked during such time periods, some vague language we have there, we're changing that to be during the last 24 months to make it cleaner as to what we're looking for when someone will qualify. And finally, the last section there, we're putting that same standard of making sure there'll be automatic review of that if there is objection by a court. That's the meat of the bill. I started with the real impact of this. While some of this stuff seems simple, we think that clarifying this process, simplifying this process is going to help, again, these people in our state that have done everything they're supposed to do. They may have made a mistake, but they've proven they're ready to move past a mistake they made in their life and actually help them become more productive members of society. Before I close, I'd like to thank the folks that brought this bill to me. This was not some brilliant idea that I had. the great folks of the Georgia Justice Project brought this idea to me and a couple other senators last year in the off season. They joined with the Faith and Freedom Coalition and came together in a working group, and we're looking for certain things that we, despite all of our criminal justice reform, certain things we still can do in the code to move us forward in those areas. And this is one of the things they brought. And since then, we've had great support from the Metro Chamber, the Georgia Chamber. There's so many different groups. The Reform Alliance that have come out in support of this. So I think some of those folks are going to speak today. But that's the bill, Mr. Chairman. I'll be happy to take any questions.
Thank you. And I just want to take a moment of privilege to say that, when I first, now it was 16, 17 years ago, when I first started my career and I was an assistant DA, and I was assigned to a judge who became, who's really become one of my great mentors and frankly just one of my dear, dear friends. And Sam Olin's is going to be able to tell him because he's also one of Sam Olin's dear, dear friends. But Steve Schuster, Superior Court judge in Cobb County, and I was a brand new prosecutor. I hadn't even passed the bar yet when I tried my first case in front of him. And as I would negotiate pleas, I would negotiate, 10 years probation or 10 to do 1, 5 to do 1, 5 years probation. And he would, and Judge Schuster hates probation. Like he wants probation to be, he's very much in line with kind of philosophically this. And he would always change the sentences that I negotiated to early terminate probation after 3 years or after 2 years or whatever it may be, if they've complied with everything they're supposed to do. And over time, I began to realize that was a really prudent thing to do because it gave a carrot to a person to do the things that we needed them to do and to behave, and then to give them that incentive. And so as I moved on from his courtroom and was later assigned to Judge Flournoy and later Judge Lark Ingram, I took that kind of philosophy with me and would oftentimes negotiate with the defense lawyer early termination provisions if they complied with everything. I think it is a good policy. It happens a lot right now, as is. I mean, it's something that I think happens all over the state, but there are probably there are judges in places that have no interest in that happening, and so I think that putting this into code and creating this right is a good thing to do. I think that it's interesting in line 169, 170, the difference between being compliant with general and special conditions versus having their probation revoked. That's important because compliance is oftentimes you'll have somebody that's behind on their fines and fees. They just didn't have the money to pay their fees, and so they're technically out of compliance. A lot of times what happens is the probation officer notices them to come in for a compliance hearing in front of the judge, and the judge in a lot of situations will not revoke that probation. They will just say, okay, here's what you need to do. We're going to get you back on track. And so that does not result in a revocation. And having that broader, I just think that allows judges, probation officers, and prosecutors to work on a more individual basis with these folks that are really trying to do the right things. They've taken responsibility and accountability for their actions, and they're trying to comply with probation. They just have circumstances that are making it not tenable. And so I think that's a great change in this as well. So I'm very pleased to see this bill. Representative Saines, did you have a question for the author?
Thank you, Mr. Chairman. Quick question on the behavioral incentive day. If it isn't written in the sentence, it's 3 years. Does that shorten what does that create in terms of eligibility by putting that 3 years? Is that just a standard time frame that it would have been in place anyways, or does that shorten or make that day quicker to be eligible?
So it's a good question. That's the existing law, though. So the bill doesn't change that 3-year part. That's in the bill, you'll see. But instead what we did is streamline the process once someone meets that time period. But that 3 years still remains in the code as it is now.
For like example, if a judge sat on it for 9 months, then that they may be off probation by the time, the person could feasibly be off probation by the time the judge got around to being able to reviewing it and signing it. And so I think that tightens that time frame up and requires a swifter action, which I think is a positive thing.
And in fairness, you may be looking at line 57 where we did put that in. And that's because you have circumstances where while the law allows for those behavioral incentive dates after 3 years, judges are not putting them in orders. And that's the part where we confirm it has to be put in order. And if it's not, it's assumed by law that it's there.
Mm-hmm.
So that is an add in there. But the intent is, as the chairman said, is to make sure that we actually meet that 3-year threshold versus waiting for months for a hearing or someone to finally notice, oh, you're eligible. In my private practice, I had a kid whose dad called me about a case, and it turns out in looking at the order, the kid qualified for behavioral incentive day summer a year ago in summer of 2020. And it was a good example. While had this bill, I don't do hardly any criminal law, it just worked out. I got a call about this and had an Exhibit A. Person qualified for it, but in the summer of 2020, they showed their probation terminated. The kid remains on probation today, and now it's moving with the court, as I said something, and it was never put in the order, and the ball was dropped on it.
One more question.
Please, yes.
All right. I know on a bill that is in your committee that PAC had helped with, there was an add-on that the state had to take it before the judge. It was a requirement of DCS to take it before the judge, so we were sure that upon 10 years it was reviewed. Is that utilized in this? I'm trying to read between the... Is there a reason the state couldn't, upon the time of eligibility, immediately take it to the court for a review, or is it that on most cases it doesn't have to go before the judge because there's no objection and it just gets terminated?
And so if there's not objection, you still need an order signed by the judge completing it. And so I think, and some of these other people after may want to speak more on this, but I think the problem is you have probably however many circuits there are in the state, you have probably that many different ways it's maybe being done. I know even in my private practice, mainly a civil practice, every court does things differently with their calendars, every circuit, every judge sometimes. And so there's probably not a clear answer as to how it works in every corner of our state. And hopefully the intent is here to streamline that, to have the same process everywhere, because you still have to get an order to the judge to sign off on this. If the order just sits and the judge doesn't even know it's there based on their process, then nothing's happening at that point.
I think it's a good bill, and I think to add to the more people we put out of probation or out of community supervision that don't need to, the more time our DCS officers have at monitoring sex offenders and doing things that are of public interest. So thanks for bringing it to the committee.
Great point. Thank you.
Okay. See nothing else. I know you're supposed to be somewhere else right now. So what I'm going to do is I'm going to hear this testimony, and I will, if there's anything of consequence, then you and I will talk, but we will hear this and hold this today, and we'll bring it back up next week. So
thank you,
thank you, Chairman Strickland. There are a lot of people that have spoken, that have asked to speak today, and so here's what I want to do. I want to honor that and let everyone that wants to talk do so. I have to be somewhere in 45 minutes, so what I would ask is that everybody please be respectful of that time, and also let's try not to be duplicative of each other, if that makes any sense. And I also want to. You're not signed up to speak, George, but George Ray, I want to thank you in the back there. You have worked for years on this issue and issues like this, and you and I have been working together for you, and I very, very much appreciate your commitment to this and working and getting, a good product. But I'll start with Sam Olens. And again, everybody, remember, we're done at 3:00. So, and actually we're going to be, there's somebody that wants to speak on one of the prior bills. So let's try to have all this testimony wrapped up by 2:50. Thank you, Sam.
Chairman Reeves, thank you. It's a pleasure to follow Senator Strickland for the great work he's doing. And to support the Reform Alliance along with the other members of the group. I'm going to be very short with you. As you know, this is a bipartisan bill. As you know, there are folks from the full political spectrum supporting this initiative. This bill clearly supports the initiative started by Governor Deal and Justice Boggs. The prior bill from 2017 was nice in theory, but it hasn't worked in practice. There are now over 50,000 folks that are eligible to have probation terminated, and only a little bit over 200 have had termination ended since the bid was first started. So this is, as Senator Strickland stated originally, is candidly a streamlined effort to clarify the law and to greatly assist those individuals who have earned the right to have probation ended. And at this time, I will sit down.
Thank you, General Olens. And Sam is a great. He's our former Attorney General. Has offered consistently great testimony for this committee, and it's an honor to call him a personal friend. Skin Edge, why don't you come up here, Skin?
Mr. Chairman, members of the committee, I'll be brief. I'm Skin Edge. I'm here today on behalf of Koch Industries, that's K-O-C-H, and Georgia Pacific. And we wanted the committee to know that both Koch and Georgia Pacific support Senate Bill 105, the probation reform bill. These companies support a variety of criminal justice reforms, especially efforts to remove barriers to entry so that individuals who have paid their debt to society and fulfilled any restitution obligations are provided the opportunity to become productive members of society once again. The state of Georgia has been a leader in criminal justice reform. We think this is just yet another step in that march forward. So we appreciate your consideration, your favorable consideration of this bill.
Thank you, Mr. Edge.
Thank you.
Next, I'm going to call Lisa McGraham or McCahan. I can't read the. Yes, okay. Thank you. Tell me how to say your last name again.
I always say the H is silent, pretend it's not there. McGann.
McGann. Thank you. You're from the Georgia Justice Project,
Yes,
right?
hi.
Yeah.
Thank you, Chairman Reeves. Thank you for having this committee. This committee hearing. I'm Lisa McGann. I'm the policy director with the Georgia Justice Project, and I'm here with my colleague Rachel Holmes, who is the managing attorney, and she spearheads our early termination probation clinic. I'm going to be really quick as well. I'm just going to summarize why we're so supportive of this bill. It sets clear criteria for what defines good behavior. It creates a uniform court process and court standard, and it eliminates the confusion between the existing pathways, and that's really important. That's why I think we've had so many hurdles with getting early termination in the past. It also, I want to point out, will help tens of thousands of individuals who have proven their rehabilitation by exemplifying good behavior and being law-abiding citizens. It will save taxpayer dollars, and it will finally address the egregious number of individuals who are serving a long probation sentence in Georgia. And I think that's exactly what the reform of 2017 wanted to do. So thank you very much.
Thank you. Adam Pipkin from the Faith and Freedom Coalition. You guys are doing a great job of being brief. Thank you. It's awesome. Keep it up, Adam.
Yes, sir. Members of the committee, Mr. Chairman, my name is Adam Pipkin. I am the Executive Director for Faith and Freedom Coalition of Georgia, and we strongly support this bill. Georgia has more people on probation and parole than any other state in the country, and we would like productive members of society and those that have done all that they've been asked to do to be able to be at home with being good mothers and fathers and being productive members of society. In 2019, 1% of people on probation, only 1% created new offenses, and over 25% of everybody that entered prison was from a technical violation for probation. And so we think there's a lot we can do to limit the amount of people on probation, and this is a good start. So thank y'all.
Tony West from Americans for Prosperity. Hey, Mr. West.
Hey, good to see you all. I'm going to just really duplicate everything I said, so I'll be very, very brief. We support this bill as well. We're for anything that's removing barriers in government policy that keep people from pursuing their American dream. And as everybody's already testified, as Chairman Strickland said, there are heavy barriers that keep people from improving their lives. So thank you for considering this bill, and appreciate the support.
Thank you, Mr. West. Simone Price. And Ms. Price, you testified on, weren't you in Judiciary last week on the citizens arrest bill? Or am I?
I was watching from afar, so I was
You were
not
watching
there,
from
Mr.
afar. Okay,
Mr. Chair,
okay.
no. But it's good to see Mr. Chair and
Yeah.
members of the committee. I am with Reform Alliance, and former Attorney General Sam Olens said wonderful things. I just wanted to say briefly that I do think that it's evidenced, and you'll find in some of the information that you have in front of you, that there are diminishing returns to community supervision after a certain amount of time. 18 to 24 months is a really well-documented time period for when it's important to front-load cases, and that if folks are going to commit another crime, they would have committed one within that time frame. The only thing that I haven't heard mentioned that I do think is compelling is that it also increases the criminogenic risk to over-supervise people who are otherwise low risk. So the punitive sentences, lengthy supervision terms, those do not help individuals who would have no reason to reoffend, have no intention to reoffend, but can increase the likelihood that they will reoffend. And we do support this bill and consider it to be one of just radical practicality, regardless of your reform inclination on other issues. So thank you.
Thank you. Is there anybody else in the audience that wants to speak on this bill? Anybody in the committee have any closing comments? We're going to hold this today and bring it back up next week. I do want to say, just for the benefit of the committee too, that this hasn't necessarily been brought up directly, but one of the very important aspects of this bill is how it relates to restitution. Obviously, when people are the victims of a property crime and something is taken or stolen and they don't get that property back, then part of the process is, and part of their probation sentence is, they're ordered to pay restitution that is of the relative fair market value of whatever it is that is lost. And that can be a very frustrating thing, because it happens all the time where they simply don't pay that back. And I believe that further streamlining the incentive to get off of probation will really encourage folks that owe restitution to get that money paid back. And I think that a lot of crime victims, they see that their perpetrator or offender went through the court system, was convicted, and they lost not just a $2,000 computer, but everything that was on that computer, which is a lot more valuable than the computer itself, and things like that, that feel a sense of they didn't get full justice because they didn't really get restitution and it wasn't paid back to them. And some judges will revoke probation for failure to pay restitution. Some judges don't. But I think that but what's important to know is that this option would not be available to somebody who has yet to fulfill their restitution requirement. And this is a good policy for Georgians, who are on probation, but it also embeds some protections for those who are also victims. And so I think that that's important to note. I do know that there is one other person that we're gonna hold this bill, bring it back next week. Is Tracy Chu? I don't know if I'm saying that right. Yes, and you wanted to speak to us on. You came over today from Athens, is that right?
Yes,
and you wanted
correct.
to speak to us on the prior bill that Pro Tem Miller had brought concerning the inappropriate relationship or whatever.
Yes.
Please introduce yourself and feel free to address the committee.
Okay, my name is Tracy Chu. I am just a mom, and the victim that CR spoke about is my daughter. So obviously, this bill is very important to me. And one thing we had discussed in the hallway was the main reason that my daughter, at 17 years old, came forward to even file charges was because she wanted to prevent the chance that the same thing might happen to someone else. And the way that the law is currently written, we don't feel like it accomplishes that goal. She obviously was victimized by a predator who very carefully planned what he was going to do to her. Once she realized what had been happening and she was able to step back away from it, I'll never forget, she looked back through her phone at text messages that he had sent her. And she
she was right there in the middle of it happening. And the whole time she was questioning it, going, no, that he doesn't know it's happening. The whole time he's grooming her and she just doesn't even realize what's happening. And when it finally clicked in her brain and she realized what was happening and she looked back through her phone, I'm standing there and I'm looking at my phone and text message after text message after text message comes through from him to her, getting worse and worse and worse. What he did to my daughter is not a misdemeanor. It was not an, oh, hey, I think I'll try this today. He is a predator. He did it on purpose, and because of the way the law is written, he can be doing it again right now to anybody he wants. He's at home, having a good time with his family, not thinking twice about it. My daughter thinks about it every day. I think about it every day because I paid him to do this to her. I paid him to train her. I'm a school teacher. I know some of the concerns were the fact that the position of trust is a broad phrase. In my mind, I think it's a benefit that it's a broad phrase because it shouldn't be a bad thing that a large group of people are expected to do the right thing. For it to be a broad thing that a lot of people are considered to be in a position of trust and therefore are expected to treat other people well, I don't understand why that's a problem. I go out of my way every day to make sure there is no question at all that any parent of any student I have ever taught could ever wonder if I have their child's best interest at heart. Why is that a bad thing? Why should we start backing off of who should be considered in a position of trust and who should not? Why can't we just say, you know what? Do the right thing. If you have anyone who trusts you and thinks that you have their best interest at heart, then just do the right thing. My daughter, my husband, and I, and my son thought that this sick predator of a person had my daughter's best interest at heart. He did not. He took advantage of her, and she has to live with that for the rest of her life. Because of the way the law is written, he and his attorney were able to manipulate the court system, and he has no consequences of it for the rest of his life. He goes and he does what he wants, when he wants, how he wants. He's not on the sex offender registry. He doesn't even have to report to a probation officer anymore. I am begging you. I cannot change what happened to my family, but I am absolutely begging you to please change the law so that other families don't have to do the things that we have had to do. You have the power to change that. And as just a regular person, I'm asking you to please, please seriously consider doing it. Thank you very much for listening to me.
Thank you. Thank you. And before you have a seat, thank you for coming and talking to us. And I'm really glad that we were able to hear from you. You very compelling testimony, and I can't imagine what your family's been through. And you know, one of the things, I've been chairing the subcommittee for 5 years, and with there's a lot of responsibility that comes with what we do on here, because when the reason why we try so hard to get this right, we pass laws, they become law, we all go home, but if we're not as strictly attentive as we're tasked to be, then sometimes incidental things that we didn't intend happen, and people that are outside of the scope of what we're trying to address with exactly what you described end up in a situation that wasn't supposed to be. And so, you know, I say this a lot, we do good in here by really peeling all the layers of the onion back and getting to the root and making sure that every single word that this committee and the Judiciary criminal committees of the House and Senate pass some of the most consequential laws that come out of the entire General Assembly, and they affect people. And we have to make sure that we get it right. And that's why we have a bicameral, we pass bills in here that go over to the Senate, and these exact dialogues happen over there, and we put two sets of eyes on it. And that's an important part of the process. And I don't want anything that I have said or that the committee has deliberated about whether or not it's too broad and whether or not that it potentially captures something that we wouldn't intend to. Please don't think that is us failing to act or not wanting to act. We just want to make sure that we get this right, and that's our job. And it's hard, and we get criticized a lot for it. As chairing this committee for 5 years, I've taken a lot of criticism, and that's okay. That's what we're supposed to do. But we're going to take this issue very seriously, and figure out the best policy, because this is taking something that was constructed in a way that was intentionally limited, and we're gonna take that and broaden that now, and that and this initial framework of this bill, just by happenstance, it came out of this committee, so there is history here, and there were decisions that were made that intentionally limited things, and now we're looking at broadening that, and so we're going to be very deliberate about how we do that. And so I thank you for being here, and hold us accountable. Come back. I will. Be in touch with us. We want to get this right. So there's a few comments. Representative Saines?
I'll be very quick, Mr. Chairman. I echo your thankfulness for that testimony, and just want to note I've been somber privilege of working on a lot of forensic interviews on cases like these, and I know you noted your daughter's messages and going back after the fact, and it's incredibly not abnormal in terms of judging when they're in that situation. They're the victim of a very skilled intent, and that's not abnormal. But her willingness to be an important factor in advocating for the prosecution, and I know that fell short in this instance of what y'all want, but y'all are continuing to try to safeguard additional families from this harm. So I'm incredibly thankful for you being here and your daughter's leadership. It sounds like she's a striving young lady at UGA.
Thank you.
Representative Lopez.
Thank you, Chairman. Just want to echo my colleagues and thank you for being here. I'm a mother of 4 and have 1 daughter, so thank you for your courageous testimony today. We are going to be thinking about you when we're deliberating on this bill. Thank you.
Thank you.
And then finally, Chairman Burchett.
Ms. Chu, I can't tell you how much it meant to me for you to come testify for this bill. Please come back and stay involved.
Yeah.
Thank you.
Thank you so much. And we will be. These are 3 good bills. We're going to look at them, and we'll be back with them next week. And this committee is adjourned. Thank you, everybody.